On this week's episode of Industry Relations, Rob and I discuss the DOJ, the Court of Appeals, CMLS, cats, dogs, and rain. Let's go.
This is Industry Relations, a podcast that's at the intersection of real estate and technology from an insider's perspective, with Rob Hahn and Greg Robertson.
Hey everyone, and welcome to another episode of Industry Relations with Rob and Greg. This is your co-host, the notorious Rob Hahn, and as always, the fabulous Greg Robertson, but checking in from a hotel somewhere. There you go. That Superman in the house.
Oh man, I'm always in a hotel, it seems. I think I gotta go look back at these.
Weren't you kind of off the road for a bit, after you sold your company and stuff? It feel like you weren't traveling as much?
Yeah, I just...
are you back on the road?
You commit to these things like 4 months ago, and then all of a sudden they show up and you realize, wait, I'm supposed to be in Jackson Hole one morning and then Bend, Oregon the next morning. I mean, it's just, I'm an idiot. I'm just an idiot.
The road warrior lifestyle, man.
Yeah.
Play that Metallica song, On the Road Again. Here I go. Anyway. There's some big news. As we're recording this, it is Friday, April 5th, and some big news dropped this morning.
Big news? I don't know if it's big news, but okay.
It's big news. I mean, you and I have been predicting it for a year. I mean, I went back and looked, and I think I wrote a post in June of 23 saying, oh, this is going to get reversed. Don't celebrate too early. This will get reversed. But what we're talking about, of course, is that the D.C. Circuit Court of Appeals has ruled in favor of the United States in the NAR versus U.S. lawsuit. Just to remind everyone, this is the lawsuit that resulted when the Department of Justice and sued NAR, entered a settlement at the same time, and then they withdrew from the settlement. NAR brought a lawsuit saying, wait a minute, we have a deal. The lower court said, yes, agree with NAR. I said at the time, this is ridiculous. Like, there's no way. Got kicked up to D.C. Circuit, and the D.C. Circuit just reversed the lower court. Therefore, the Department of Justice is now freed up to go after NAR once again.
Excuse me.
Bless you.
Well,
that's the decision, right?
I don't quite remember it that way, Rob. The way I remember it is that they had agreed to this. The government had agreed with NAR on this settlement. Excuse me.
Bless you.
I'm in God's country here, so it's a lot of things I'm not used to. That the NAR and the government came up with a settlement, and then the Biden administration came in and basically tore it up, and the NAR sued. And you said there's no way that
the trial court
NAR is going to win on this. They're not going to win, and they did win.
Yes,
they won, and so it's like, wow, you were very surprised about that.
Very,
and then yet you were correct in this analogy that you said, but they're never going to win in appeals. So I guess you're like an even Steven there. It's a win and a loss, and then a win. So you're kind of I suppose, maybe even yourself out there.
I suppose. I mean, the thing about appeals, though, is when the appeals court slaps down and reverses, not just remand, reverses, that kind of implication is that the lower court was wrong. So there's that. Now, here's the thing. In your favor, should NAR appeal to the Supreme Court and Supreme Court disagrees with this court, then
okay, but let's and why I was pushing back on your first thing about like this is big news. So to me, this is not really. This is only that if they want to, right? And in fact, but if you looked at the original agreement, it was always in the agreement that they could go and still investigate if they wanted to. So I mean, this is a little bit of much ado about semantics in a way. I mean, semantics. I mean, I don't know if it's really that. It's not like saying, okay, because of this, shit's going to happen. I mean, the DOJ has been writing SOIs, and they've been meddling in a lot of things with or without this settlement, right? So I don't know if it's that big of a news story right now. I mean, it's interesting that, yes, and at the end of the day, if they don't appeal to the Supreme Court, you were right that, this is ridiculous and it was going to be there. But I mean, I think also the industry's moved on. We got bigger, whatever was in that settlement, there's bigger problems now. So it's almost, that stuff is like ancient age thing, right? So
kind of.
Okay, kind of. I'll take a
here's
kinda.
the kind of.
I'll take a kind of from Rob Hahn.
Yeah, here's the kind of, right? So like I said, ever since the NAR settlement's been filed, I've been just like getting hammered with all these, requests for investor calls and things like this. And one of the things I always point out, because they always ask, the NAR settlement looks so different than what the Department of Justice said in the no-select intervention, right? When they did the statement of interest in no-select, which I don't know if we'll have time, but we should probably get to the CMLS amicus brief about that settlement. So the question that I would always get is like, is the Department of Justice done here? Like, why wouldn't they just come back and intervene in this NAR settlement? Because what the settlement says in the NAR case is so different than what the DOJ seemingly wanted in the no-select case, right? And the answer I've always given is, and you and I talked about this when we first talked about in our live stream, right? Like Ketchmark has said that he talks to the DOJ all the time. Department of Justice, like they're very, whatever, they have a work relationship, whatnot. And the lawyers, at Cohen and Hagen's Berman, and these are the best lawyers in the world. I don't think they're going to go through this trouble of signing a settlement agreement, announcing it, having New York Times cover it, if they thought the DOJ is going to come back and smash it, right?
Yeah.
So the assumption we've both made, everyone sort of made, is clearly there's been some sort of signal given, some sort of wink, some sort of something. Right, exactly. That suggests the Department of Justice is not going to come in with some intervention on this settlement. Okay. And the question then, of course, becomes, what's the DOJ doing? Right? Like, what could they be thinking, given that in no-select they said one thing, and then this settlement, it's like almost the exact opposite.
Well, but it is and it isn't, because, again, I'll go back to what I said. It's a nothing burger to me, because within even that original NAR settlement, there was always a phrase in there: we may come back at any time to XYZ. Right now, and then if we go flash forward to this settlement, and which is why I think it got through, it says at a future date, if there are other changes or things added, you have to do that to be involved in the settlement. So I think, like, basically DOJ has got a free hall pass, that if it doesn't work out the way they want, they can change it later on. So let's get something on the books. Let's get a W, right, on the books here. And then if it turns out that, like, somebody's found a loophole that we didn't think about, they may be able to kind of go change that again.
That's right. That's exactly what I'm getting at. So in other words, so one of the things I've been telling investors is, look, what we don't know is maybe the Department of Justice felt like, you know what, we've taken the civil lawsuit as far as we can, right? We're not going to intervene in this case. Let the settlement stand. Let the lawyers get paid, right? Sure, it's only $400 million or whatever, right? It's not $400 billion, but Department of Justice doesn't actually have a huge interest in bankrupting a whole bunch of real estate brokerages, right? Mm-hmm. Like, their interest is destroying NAR, not a whole bunch of real estate brokers. So they're just going to say, we're just going to let this one go because we know that we're going to win the DC Circuit case, which lets us get involved directly. Right? And which is what you're saying. Right. So it's not working behind the scene. It's not working from the shadows with like an intervention here, intervention there, talking to Ketchmark. It's not that. Going forward, it's going to be, okay, cool. We're getting our power back. We're getting our mojo back. Because keep in mind, as long as that trial court ruling stood, the Department of Justice really couldn't go in and start investigating, right? Start taking direct action, right? Now they can. So maybe the thinking is,
but they've been taking action, right? They've been writing, they've been involved in that stuff. They wrote a whole statement of interest. I mean, that's
It's taking action, but it's not direct action. In other words, the only they could do is like, hey, we don't think this is the right thing to do, Judge, so don't accept this settlement. Going forward, they could just like, okay, here's now a civil investigative man to NAR, bunch of MLSs, turn over documents, make witnesses available. We are now going to directly right? Like, take your statements. We're now going to send the FBI in, because guess who the FBI is part of, to dig through your records. We want to, like, now their hands are untied, right?
And I think, on a larger scale too, with the DOJ and I guess the FTC or something.
Yeah.
There is a lot going on out there. This is not an isolated incident. This is a directive, right? Apple's being sued. Amazon's being sued. The yacht brokers are being sued.
Yeah.
This is a whole big, so realtors should not feel picked on. I mean, everybody's kind of getting their comeuppance right now with the way the things are going on here. So it's, and I'm surprised that these guys can do all this stuff at the same time, right? And maybe they're not going to like intervene because they got bigger fish to fry. They got Apple to fry now, or whatever else,
sure.
Right? I mean,
but this is where kind of what I've been talking about for a year now starts to come back into play, which is to say, you're right, they have much bigger fish to fry. So it may be the Department of Justice just looks at it and goes, you know what, we're fine. We're going to go after Apple. We have other things to do.
They got the headlines they needed, you know, the false headlines, let's say, but they got the headlines they wanted, right?
That's right. And I think there's a party that really wants to agree with you there. Okay. But there's another part that I've been warning about this for a real long time, which is, let's say when the Department of Justice withdrew, to your point, Biden comes in and we're just going to throw this deal out. I know we had an agreement. We're going to throw it out, start over, right? If at that point NAR did not fight them, if at that point NAR said, okay, it sucks, but it is a new administration, we understand. Fine, here's the documents. Let's work on another settlement, right? Let's work something out. Instead of, we're going to sue you, and then we're going to win at the lower court, which now forces you, the Department of Justice, to spend a whole bunch of time, whole bunch of money, because, even though they're government agents, they have unlimited pockets, our tax dollars funding them. Even then, like, instead of them being able to focus on Apple or yacht brokers, now they have to devote some attorney time to going to court, filing a, bunch, whatever, right? Doing the appeal. I think what I said was, look, Department of Justice is not a robot. It's made up of human beings. And human beings are going to have human being considerations like revenge. Like, fuck these guys. Right? So you're right. They have much bigger fish to fry in a sense. Like, we have a settlement. Like, we're going somewhere. Like, there's stuff happening in the real estate side, and you probably should be focusing on Apple and Amazon and whatever else, right? Whatever else is happening. But I'm just saying, there's going to be an element of fuck these guys. Right?
Well, let's go back to what we talked about last week. Just a little. There's 2 points here. So there's already been precedent that says, okay, we can have a settlement, but I might just tear it up.
That's right.
And the DOJ has set that precedent, right?
That's right.
We now have another settlement in front of us, right? And we've already got the precedent that, like, oh, it's okay to tear something up. Now, I don't think this is going to happen, but it goes back to our other discussion of, like, is there a little bit of wiggle room here, right? And we'll see what happens and goes on there.
Sure.
But I think that there's a little bit of that in that kind of thing. And then one thing before we move on, just to kind of have a little follow up to last week, because a lot of people have reached out to me about this, and a little bit of wanting me to ask you this question.
Okay.
Because you have portrayed this settlement agreement as throwing the 94 $2 billion brokers under the bus, right?
Yes.
And the thing that I'm getting from people is like, are they in a worse position than they were before, or are they're still in the same situation they were before the settlement agreement? And maybe you could argue there's a little bit better because some brokers are covered, but I mean, aren't they just back where they started? I mean, how is this throwing them on the bus if they're back where they started? Because
the line means their competitors. Again, it's the whole thing. Like I said, I did 2.1 billion last year. My competitor across town did 1.8. He doesn't have to pay a thing. I do. How am I in a better position? How am I in the same position I was? Because before the settlement, both of us, both me at 2.1 billion and my competitor at 1.8, we were both worried.
Yeah.
Going forward, they're not. They're like, oh, cool. Guess what? We don't have to write a $5 million check. You know what we're going to do? We're going to spend $5 million recruiting the agents from the $2.1 billion company.
Right.
So yeah,
no, and I think you've said that from the beginning, and I think that's a valid argument. I just wanted to put it out there, like
I hear you.
To further explain your kind of thing.
I hear you. Right.
There was a video made from NAR that talked about, hey, they're in no worst case, and I think that nuance there is, I think, important for people to know. Sorry about that. But go ahead.
No, and here's the thing. I'm saying that's not nuance. Right. That is not nuance. Like NAR fucked up bad because of that, drawing the line. They would have been better off going to the lawyers saying, you know what, here's what we'll agree to. We'll agree to every broker paying 25 bips in order to join this. Okay, we'll agree to that, and then go through mediation.
Well, we can rehash all that stuff, but I think we both agree.
Let's go back to
there could have been another place, but you're in the heat of everything, trying to get things done. That's what they could get at that point, and that's what they got. So
So let's go back to this. Like, here's where things aren't exactly like the way you frame it. The settlement agreements, of course. Here's the issue: they have an agreement, NAR and these plaintiffs' lawyers, right? It hasn't been approved by the courts. So until it's approved by the courts, it's really not an agreement, right? In other words, if, let's say, before court approves this, the plaintiff's lawyers or NAR, either one, walks away, said, yeah, screw that, we're going to cancel that. I know we have a signed contract, but we're walking away, right? In theory, you're right. Like, you can't sue them but we have a deal. It's like, but the court didn't approve it, so we don't actually have a deal, right? It's one of those contingent agreements. So that part is true.
Wasn't the previous agreement a contingent agreement as well?
Yeah, pretty much, because okay, we have an agreement, but federal law, and this is what I talked about, I think, when we discussed it back in 23, there's something called the Tunney Act. So without court approval, this is not valid, right? So you don't really have an agreement until there's court approval, right? So same thing, right? So from that sense, sure, you've set a precedent. But not really. Like that, it's not the Department of Justice set that precedent. It's like every one of these agreements that until there's court approval, you don't really have anything.
Yeah. Right? Well, I mean, it's interesting because you had your third take on this, and that third take was like, let's not overreact here. Mm-hmm. And now, listen, this could be me because I'm trying to like always find a win here, but I felt like, what, that feels like Rob has been listening to me, right? Rob is saying that, that. It's not final right now. We're not, ink is signed and everything else. There's there's some hope maybe here.
Yes.
And I thought that post was like, maybe it was like one of those, those slight little singles, single that you were telling, that maybe you were listening to me a bit, that like all is not done here, right?
No
because
question.
Before you were really like, it's
yeah.
concrete, right? It's done.
Yeah. So yes, if you want to say that I am enormously influenced by the fabulous Greg Robertson, that is entirely true.
That's
so look, I mean,
you got me.
I mean, look. So the way I look at it is the reason why this thing is quote big news is because it's big news, right? It's like, oh, NAR settlement, and then look, another loss. Right, it's like now that the Department of Justice is freed up, they're coming after you again. So it's one of those things. But you and I have always said, look, they're going to come after you. Right, it's just a matter of time. Now they could do it nakedly, they could do it directly. So what we don't know is, will they? No one knows. No one knows. My guess. So I'll just speculate. My prediction, my guess right now, is that the Department of Justice likely does nothing until the elections are done. They might start investigations. They might be like, cool, the court just freed us up. Here's a bunch of civil investigative demands. Start answering our questions. Start producing documents.
You mean if they even if they sign the whole thing, they would still go through with that?
Wait, sign what thing?
The settlement.
Of course. The DOJ is not part of the settlement. Right.
Well, I mean, they've been actively involved in like these different decisions out there. So you would think that would just be to me incredibly bad faith of like letting this go through and then without saying anything there during that agreement, and then afterwards starting a big fuss. I mean, I think that's just I don't know if that's not fair play right there. But I mean,
it's not that I mean I agree, but here's the thing, man. You've pissed off the DOJ.
Yeah, but they won. Now you pissed them off. Well, they have in a sense where They pissed them off that, like, okay, the lower court said, you know what, NAR is right.
Sure.
And they went to the appeals court and they said no. So they at the end of the day, unless they go to Supreme Court, they've won now. They can take that W, and you think there's still
well, what if they won?
More bitterness? Huh?
What do you think the Department of Justice would want now? Now, today, settlement, all that. What do you think the DOJ would want now?
I think all we have to look at is in the Nosovec, the SOI, in the Nosovec case, they've laid out. Remember, we were famously going, they've never said what they want. Yeah. They said what they want in that statement of interest.
That's policy. I'm saying if you're the lawyers at the Department of Justice, what do you think those people want? Do you think they want policy changes and benefit American consumers? Is that what you think?
They want blood is what they want.
They want blood. That's my point. Right. So what would winning look like then for the Department of Justice if they want blood?
Listen, I'm not putting that on the universe, man. I'm just not. You can say it. I'm not.
You're not putting it on the universe?
I'm not putting that out in the universe.
Gotcha.
Yeah.
Well, okay. Well, I mean, I've already stated it. It's like, look, this has been going on for 100 years, right? Like the DOJ and FTC has been fighting NAR for 100 years. So to me, it's like what they want. If they want blood and they're feeling vengeful, they want NAR bankrupt. They want NAR smashed. They don't want brokers smashed, right? They're not after brokers. They're not after agents.
I just think if you want that, now is the time to do that. Not in committee hearings and all that later on. This right now, what's going on? It's like, just, you know what? No, $418 million is not the time is not enough. We need to be at least $2 billion, and then just do it now. Why would they wait until later on to kind of finish the job?
Because if you do it now, then you maybe unravel the settlement agreement, and Biden is running on housing, and I'm saving American consumers $30 billion, and settlement agreement by NAR. It disrupts that narrative. That's why I'm saying I don't think the DOJ does anything other than investigations, other than send us info, right?
So hold on. So if Biden wins, though,
if Biden wins, for sure, I think the wrath of God will descend upon NAR. If Biden wins. If Trump wins, questionable. There's some open question marks there.
We won't have a democracy anyway, so what does it matter, really, right? So
I'm all for monarchy at this point. So if you're telling me that Trump is going to be crowned king like that might make me want to,
Oh, God. Good Lord. Okay, well, let's go.
That's
go ahead. Sorry.
Big news, all right? Now, before we transition to the second part of this, we were asked by our producers to make a plea to our audience. If you are listening to us on audio, would you please go visit our YouTube channel? It's just Industry Relations, and sign up to subscriber, because we're very, very close to monetization, which allows us to pay our producers better or at all, which would be great. So if you could do us that favor, that would be really nice.
And I will. I'll give a little hint here. A little bit of for our listeners. We're getting pretty close to maybe having a sponsor here. And I'm super excited. I don't want to jinx it, so I'm going to knock on wood here. But yes, I think there's a company out there that's forward thinking enough to think that they're going to be reaching the right audience with us, that's and right. I would be thrilled to have them. So we'll see what happens here.
We'll see what happens. And if you have anything you're trying to promote or pitch to, say, like the Department of Justice, I'm just saying, we know they listen to this podcast, so just saying. Anyway,
okay. So let me give the segue here, because you were saying before that this was big news with the settlement being overturned. Or the decision about the settlement being overturned. And I'm saying it's not such a big news. And now, I guess, if we go into talk about the amicus brief filed by CMLS, and maybe as a kind of a tangent or something that's close to that, with it, Northwest MLS also has done something. To me, that seems like big news. But you're saying, no, that's not such big news. That's not really, doesn't really mean anything at all, based upon what I'm kind of reading the tea leaves of your latest Substack post.
Yeah, I mean, so like I just wrote this today. So obviously, by the time people are listening to this, it'll be Wednesday next week, right? So that post will be out there. Look, I mean, I wasn't even going to talk about that, man. Like, I saw the amicus brief and I was just like, who cares? You know, it's just, there's another, the NAR settlement is obviously much bigger news. You know, who cares? Until I had a friend and a reader was like, no, I really want your opinion. It's like, all right. So I go through and I read it and I go, listen, the biggest problem with the amicus brief, and like people want to pick apart like whatever economic, like fine, you're right. Like that's like, fine, CMLS, you're right. Everything you said is right. The Department of Justice got it all wrong. They're morons and the court should ignore it. Cool, you've done that. Now the issue becomes two things. Number one, now CMLS has to file an objection to the NAR settlement. Okay.
They don't have to, but I mean, if they really believe this,
right, they could just be hypocrites, right, and not file one.
God, you and your language. Okay, go ahead.
It would be like literally because they filed this one in those like saying there were largely 3 points. One, compensation is entirely lawful. Two, forcing MLSs to regulate lawful behavior by brokerages opens MLSs up to antitrust lawsuits by the brokerages. And three, what the Department of Justice wanted, eliminating compensation, is anti-consumer. Okay, if those are the cases, then NAR settlement that eliminates compensation, they must object. They have to object. Right. Otherwise, you're a hypocrite. I mean, there's no other word to apply there, right?
Okay, so again, I'm not a lawyer, not your lawyer. I'm not whatever. But sure. As far as my understanding is that when the judge in this case, the settlement case, is looking at
which case, NOSELEC or NAR?
No, not NOSELEC, the NAR case,
the NAR case,
settlement case, right? This person is not just looking at all the facts and figures about these one plaintiffs, right? They are looking at other things like precedent for other things that are going on, right? So the fact that CMLS has filed this with NOSELEC, I cannot pronounce that word.
Yeah.
I think that's on the record over there. And I do think that a judge or one of the people that are on this thing are going to take that in consideration as far as the whole kind of thing here. I don't know if they have to really both, file it in both different places. That's part of the record over there now. That's part of a record that they look at and they look for precedent and they look for other cases like this to make the kind of their decision on how this goes, right? So I don't know if it really needs to be at both places.
I mean, maybe, but no, it does have to be in both places because if you're a judge, you're not just randomly considering some amicus brief. This is not a random thing over there. This is very closely related. But my point is, it's in a different case, right? No,
but as in judgments and when judges are making decisions, they consider other cases. That's standard operating procedure, bro.
They consider other courts' decisions. They don't necessarily consider what some third party filed an amicus brief in another case.
I mean, they look at the whole record. They look at the whole record of what's going on in there.
Let's put it this way.
just again, it's the negligent. I mean, come on, man. I mean,
let's put it this way. At a minimum, here's the thing: you have to file an amicus brief, and then the court will really look at it. I mean, these are busy people, right? So I'm just pointing out.
Well, that's a different argument.
So you're basically what your point is: CMLS is not a hypocrite if they don't object to the NAR settlement. That's your point.
Correct.
Right. Because
they're on record.
Why did CMLS intervene in NOSELEC?
I think some of the stuff they had there was egregious, especially some of the way that the DOJ had put on there about some of the things that were going on in Northwest MLS. I think they got the facts wrong.
Sure.
So I think that's that to them was, and you're right, everybody's busy, so that's what they were working on. This thing just dropped a few weeks ago, right? So we know these things don't take,
I'm just saying, so why did CMLS, which is not a party, intervene in NOSELEC? Just to correct the facts? Because that's not what they did, right? They didn't file an amicus brief saying, we're not recommending you do anything one way or the other, Judge. We just want to correct the factual record. Let us show you some economic. That's not what they did. What they said was compensation is lawful. The Department of Justice forcing MLS to regulate lawful behavior of brokerages opens the MLS to liability. And three, what the Department of Justice wants by eliminating compensation is bad for consumers. Please reject the Department of Justice thing. And here's a whole bunch of evidence to support our case. Why did they intervene? You're not a party to this. They intervene because brokers, it's lawful, MLS are open to liability, and it's bad for consumers. Cool. In the NAR settlement case, they're eliminating compensation. How do you not object to that? Because the exact three things happen. If under what the CMLS said, if the NAR settlement goes through, MLS is now have to regulate lawful behavior by the brokerages, which opens them up to antitrust liability, and this harms consumers. If you don't intervene in this case, then yeah, you are a hypocrite with no principles. I'm sorry, this is an either or. I know you hate either ors.
Now they have no principles. You're putting that out there. They have no principles. Come on,
If you don't intervene, then you have no principles. So they have to intervene, okay? Which you and I both know they're not going to intervene. So now CMLS has painted itself into a corner. But the second thing, which is related to the first part of this, let's say they file this, and let's say that the judge says, you know what, you're right. I buy this. I'm going to reject the Department of Justice's statement of interest.
Oh, man, that makes things interesting. What if they do it before this thing gets signed?
Right, because
that change the dynamic?
Right, that judge is on her own timeline, right? She has to do her job. So now she's going to go, hey, fuck you, DOJ, because of what CMLS just did. We just talked about DOJ is going to keep score, man. These lawyers are like fucking pissed off. They want blood from NAR. Do you really want to get on the radar?
Yeah, you're describing an opinion you have about
it's
what people are thinking and
purely
everything else, right?
You're right.
And
you're right.
And no, and then there could be other. I could come up with another speculative thing.
Of course,
that with another story, right? So
of course,
you just have a better mind for the darkness.
You paused because you know what I'm describing is much more likely in human nature. I'm just saying, just look at human nature, right? If I'm some staff,
Rob,
if I'm
the reason this podcast work is because of what you're doing right now and where I'm at right now, right? So.
So I'm not saying this is going to happen. That's not what I'm saying. I'm not predicting anything. I'm just saying people are people, whether you are, you're me or you're the assistant attorney general for antitrust, right? People are people. We don't like it when people fuck with us. And if there's an opportunity to get back at them, we'll take it, right? That's all we're saying, right? So in this case, I'm like, my thing with this is, okay, CML, like, okay, I know you're, whoever, the lawyers, somebody worked real hard on this amicus brief, and it's good. It's really well done. Like, I don't want to take away. It's a well-written, well-argued piece of paper. I'm just saying, like, should somebody have said, hey, before we file this, can we...
Do you really want to step in the octagon is basically what you're saying.
Exactly. Like, why do we want to do this again? Like, what?
Well, there could be a simple. You're telling stories. I could tell another story.
Sure. What's the story?
Say that the CMLS membership, the MLSs that comprise that, the 250 plus,
right?
Said to the leadership of CMLS, saying, why aren't we involved in this? Aren't you supposed to represent our interests? Should we, as a group of MLSs, there are some clear problems here. Why don't you do it? And the CMLS leadership says, we were going to stay out of this because we didn't want to step in the octagon, but now our leadership is telling us, no, you have to go in the octagon. That's a story I'm telling. That's a story that could be that could be there's a multi-universe of stories and scenarios.
I'm buying it. I'm buying it, Greg. I'm buying this narrative. I'm buying the story. My only question is this: do you think the membership said that to in the last 10 days?
Again, in one scenario, yes. In another multi-universe, maybe no. I don't know.
So you're telling me after the NAR settlement dropped on March 15th, the member MLS of CMLS still went to Danae and to the board and said, we still want you to step into the octagon.
Okay, so I'm just, again, this is just pulling this right out of my butt right now. But
I'm just asking questions at that point.
I don't. Well, we are speculating. We don't know the things. I just don't. I get really, and I know you're doing this. Because there can be different scenarios, and because you're pontificating on what you think the scenario is, when it could be a multitude of things. You're throwing things out there, Rob, that when you say they have no principles, they have no, and like, well, in that narrow, case and story you're telling, maybe you could argue that there's no principles, but you have no idea what's going on. I don't know what's going on. And to throw those kind of things out there, I just don't, I get, it ruffles my feathers a little bit because we don't really know. And to put labels on like that and throw that out into the universe, I just, I don't, we should maybe find out before we start like accusing them of being this and that. But I get what you're saying. In this scenario, yeah, maybe in that scenario, if it's 100% true, maybe they are negligent. But we don't know that. And why do we want to put labels out on there?
I'm not putting like this, just logic, right? So let's take a step at a time. Okay. Like I said, I wasn't going to write about this. I wasn't going to look at the amicus briefs. I'm like, it doesn't matter. The NAR settlement has, that takes precedence. Who cares what the no select thing is? All right. I wasn't going to do it until someone asked me. I was like, fine, if you do, I'll do it. And once I do it, here's the thing. Number one, the mistake by CMLS is not that they drafted this brief. That is not the mistake. The mistake is that they filed it 10 days after NAR settlement. So the narrative in my mind, like that's why I'm asking the question. Let's just say, right? The CMLS leadership go to all the MLS and say, hey, listen, we've been working on this amicus brief for the last however many months, right? But NAR settlement has been filed. Do you still want us to step into the octagon? And in one narrative, the members said, absolutely, right? We don't care that the NAR settlement's been filed. DOJ got their facts wrong. Their analysis sucks, and what they want, in no select is terrible. Get into the octagon and beat them down. That's one scenario. The other one is none of the members said anything during those 10 days. And CMLS still said, let's get into the octagon.
And there's a pretty big difference. Number A serial C, D, E, F, G. We don't know.
So what's the CD? Yeah. Like, give me the other scenarios that happen.
Their attorney advised them without anybody else. The attorney advised, we need to say something here.
Okay.
That's a scenario.
Okay. And the leadership, the board of CMLS said, yes, let's get into the octagon because our attorney told us.
Again, I could probably come up with 10 things if we want to waste the rest of the podcast of me trying to come up with different scenarios.
Come up with three. Give me three scenarios.
Okay. I gave you two already, right? I gave you two. We're two. I get one more? Is that all you want?
No, three more from here. So here's what I'm getting at. Like, let's set this up.
Three more from here. God, okay. All right.
Okay. CMLS worked on this brief for a while because you don't write this overnight, right?
Well, when was this the SOI filed with the DOJ on this thing?
That was what I want to say
a month ago.
Hold on. When was that?
And didn't they miss the deadline for putting this in anyway? Like, weren't they asking this to be added?
They got leave to file. Yeah. DOJ SO intervention.
So we could go back to when they asked for leave, and we know at least that's a point, right?
Hold on. State interventions, February 15th it was filed. Okay.
Okay.
So the DOJ files on February 15th. CMLS goes, okay, we need to work on this. Right. They got the facts wrong. This is ridiculous. Okay. So they basically work on it for a month. Right? February 15th to March 15th is when NAR was filed. They work on it for a month. It's ready to go.
Does that, I mean, you were an attorney. Does that seem like a reasonable?
That seems reasonable.
Take that long?
Yeah.
Okay.
Yeah, it takes about a month. Right. So they've been working hard at it. The thing gets filed. Okay. 10 days pass. The NAR settlement gets filed. It drops March 15th. Right? Which makes the no select settlement irrelevant.
Okay.
Right?
Okay.
Well, there's 10 days.
There's still, I mean, if it's irrelevant, then why is it still out there? I mean, it's relevant for MLS PIN for sure, right?
MLS PIN's included in NAR settlement.
Yeah. Okay. Right? I'm with you.
So
go ahead.
Either way, I'm just saying. What I'm asking for is give me three narratives from March 15th through March 25th when the amicus briefs were filed. What was the conversation? What justifies filing that after the NAR settlement drops on March 15th in your mind? That would not make so. And then there's a part two. So give me those. Because I'm saying that's a mistake. It's just a mistake, right? And I think what happened, quite honestly, is that they were like, because this happens in organizations all the time, right? One side of the house has been working on it, and they're like, okay, cool, it's ready to go, let's file it. And the other side of the house, they're not coordinating well, right? And then it's like, oh, we filed it, cool. And it's like, wait a minute, should we have filed it? Like what's the narrative here?
Well, let me ask you a question on a scale of 1 to 10. If I mean, is this just a blunder, or is this like a?
It's a minor blunder. I mean, I'm not. So, like I said, it's irrelevant. Like, I wasn't going to talk about this. Like, it wasn't like I saw the amicus and be like, oh my god, I gotta get it. Like, no, I didn't think it was important, right? And it's still not that important. My only point is, look, we know CMLS is not going to file an objection to the NAR settlement. My point is, you've just gotten onto the Department of Justice radar. Is this something you want to do?
Right.
That's all. Right. Do I think something's going to happen? Probably not. Is the DOJ really going to expend resource going after CMLS? Probably not. Right. Like, is the NAR going to I probably not. Right. Like,
but I mean, can these two things exist at the same time? That they want to file with Nosovec, right?
Yeah.
Because of whatever reason they had.
Sure.
But they don't want to push their luck and file with NAR.
I guess. I mean,
they want something on the record.
Sure.
That they feel like that they want to get what they want to get off their chest.
Sure.
But for the reason you state, they don't want to poke the bear too much, right? And I don't know if I would label that, Rob, as being because if they don't do that on the other one because they have no principles. It could just be a decision that they made that, they wanted it on a record somewhere, but they're also taking your advice and not poking the bear too much, and not to call it negligent, and not to call it no principles. That's all. That's all I'm saying.
You're right. That's fine. Then the next CMLS meeting, they should just stand up, say, "Hey, MLSs, we filed this in NoSelect because we were trying to protect you from liability. We decided not to poke the bear in NAR. So all of you are now open to antitrust liability for regulating brokerages when they do lawful activities like compensation. And in the NoSelect case, we intervened because we ultimately care about consumers. We didn't want to push it, so consumers are fucked, and we chose not to say anything. Just so you know, please don't leave us, even though we just saddled you with a whole bunch of liability, and we're a trade organization for MLSs. We didn't defend you, but don't leave us because we don't want to poke the bear." At least make that clear, right?
Yeah. It's obviously with your legal training. I mean, it's like those. The thing is, though, and I get it. It's like you have one of those minds, and like it reminds me of those kind of like, those books you used to get on when you go on a road trip, right? They could be like circling the letters and the whatever word find and whatever. But the other ones that I used to like were the knight and knaves. Like there's three. You have to like who's a knave on the island, and you ask questions to get to who is the knight, the good guy, and who is the liar, right?
Yeah.
And that's when I'm doing this stuff with you, man. It's like, oh God, Rob is like, he's the beautiful mind is going and like I'm trying to like work my way back or whatever, and like and in the heat of things, especially like when we talk about the NAR settlement, it's like maybe somebody didn't think that if I draw a line here, that's gonna cause a problem. That just it's just in the heat of battle. That's what happens, and this could be in the heat of battle things.
Yeah.
I
agree.
Everybody's human.
I agree.
Right?
Do I think CMLS was somehow evil? No. Like I know all those people. Like I'm sure they were just like, hey, we need to do something cool.
Well, they're unprincipled, is what you're saying. But whatever.
My point is, it's a minor mistake at the end of the day, right? Like we're not going to be spending the next 6 months talking about CMLS's amicus brief. I'm just telling you, it's a minor thing, right? Like, fine, if they don't file something in the NAR settlement, is that like the end of the world? No, of course not. Are they hypocrites? Sure they are, but we all know what the deal is. Like, let's not poke the bear, right? Like, let's not fuck with the settlement that's going to make sure all of our members are now off scot-free. Like, they no longer have any liability. Like, they're not going to do that. I get it. I wrote that.
Right.
I'm just saying this amicus brief was kind of a mistake because it puts you in this position. And yeah, intellectual integrity and consistency, fine. You know what? I'm sure they'll get over it. Nobody's going around, I'm leaving CMLS because you have no intellectual integrity. Nobody's doing that. So it's not a big deal, right? All I was saying was related to the first part of this. Now is probably not the time to get on the DOJ's radar. That's all I'm saying.
Yeah. And what's interesting to me is that, the scuttlebutt I'm hearing right now is that because we got the May legislative meetings coming up here.
Oh boy,
first week of next month, right?
Yeah.
So that's going to be the time where I think you're going to see a little bit of like a rustle, a tussle of what's going to happen here. But from what I'm hearing in the kind of tea leaves reading the tea leaves is, again, my opinion too. Here, adding to that is, NAR is going to be like, no, we're doing this. This is. Get on the train. Like, we want to get this.
What? The settlement?
Yeah.
Of course they are.
Yeah.
They'd be fools not to. It's $418 million over 4 years. That's the greatest deal ever.
Without any changes that are really going to matter at all. Mm-hmm. Right? I mean, it is I mean, I understand what you're saying about, the line in the sand there and everything else, but all other ways, it's just an amazing thing here.
Yeah. So we'll see what ends up happening. I mean, it's something I am kind of curious about because I've been hearing this from a bunch of brokers where they are now really like nervous about meeting with any other brokers. Right, because part of the whole antitrust thing was that you guys get together at these conferences, conspire, right? And it used to be we get together and there would be an antitrust statement read, please don't discuss commissions, please don't, right? Now it's literally like, I don't even want to be in the same fucking room as my competitors. So I'm kind of curious who's going to attend May meetings.
I think, there's going to be, everybody's going to go. I mean, the MLS crowd has got to go.
MLS crowd will go,
policy meeting. Yeah.
Right. Yeah. But I'm just wondering, like, from a broker, like, honestly, I'm sort of curious, like, T3 summit's coming up, right? And that's usually a gathering of some of the largest brokers, leaders, right? I'm actually somewhat curious what attendance looks like at that event, right? Yeah. Again, because I've spoken to multiple brokers who are like, look, my legal counsel, my lawyer's telling me, don't be seen in the same room, like, because I could see it. Right, so we'll see.
Do you think that the recent news of Ladder and Blum being sold to Compass? Do you think there's any factors of Compass settlement on that? And I don't even think was Ladder and Blum like they were in the $2 billion club, were they?
Yeah, they were definitely in the $2 billion club. Yeah, they're one of the largest. So, they're the dominant brokerage in like New Orleans Gulf.
I think there was that a factor?
It's could have been. It might have been. I don't think the principals would ever tell us. Right, it had to be a consideration. What I don't know is because I haven't read this Compass settlement agreement. Right, it's not available as far as I know. I don't know if it covers anyone they purchase. Right, remember with the Remax settlement and the Anywhere settlement, I was making this argument. According to this, if they buy somebody, they're covered.
Yeah.
Right. I mean, a lot of lawyers have disagreed with me.
I was assuming it would be something similar to that. So
right. Yeah. Or even if not, I guess the way to think about it is Compass has settled. Right. Their liability is done. As long as they pay whatever, I can't remember, 40 million, was it 50 million?
I can't remember.
Something like that. It was less than even the what they would have had to pay. So whatever that is, Compass not covered. So they're not worried anymore about we need to conserve all this cash, right? Now, Ladder and Blum might be covered, might not be covered. We'll see, right? They're in the $2 billion clubs. We know what the price tag for them would be. It would be 25 bips on their, right?
But now you're owned half their cash, right?
Or whatever it is. But now you're owned by Compass. So for Lacey, for the owners of Ladder and Blum, they're out. We got paid, right? And then whatever damages Ladder and Blum might have to pay, that's Compass's problem now.
Yeah.
Not ours. So that,
and but again, I'm going to say that they're covered because when you're doing this kind of rubric, I mean, you're and when I'm buying this, am I buying this liability, or was that liability taken out? Yeah. Was that something that was, maybe part of it? We don't know, but I mean, I got to believe that they were pretty confident that they wouldn't.
But I'll tell you this though, like what you just raised, it's an interesting thing to think about. So remember, one of the predictions I made when all this happened was like, I think we're going to see a wave of consolidation by brokerages, right? Because I think the larger brokers, especially like Anywhere, Remax brokers, that you're covered, you no longer have to face any liability. You're going to find a whole lot of acquisition opportunities. I think Compass, Ladder, and Blum maybe shows us the pattern for that, right? Where maybe the acquisition.
If it was a catalyst, it was a catalyst, right?
Not just a catalyst, but it makes. So here's what I'm getting. Like, let's say they negotiate, because any M&A, right? There's gonna be a bunch of negotiation, valuation, blah blah blah, and then they come to, okay, cool. We think you're worth $100 million. We'll pay you $100 million for your company, right? Oh, but you have this liability, this legal liability, right? But with the NAR settlement, we know what the max liability is going to be. It's going to be additional $10 million, right? So I'll tell you what, we're going to pay you $90 million cash. We'll take on the liability, the $10 million. So you, the owners, are now free and clear. Take your $90 million, enjoy life, buy a yacht, whatever it is, right? That's a pretty powerful message, man, if you think about it. From a brokerage M&A standpoint, that's a pretty powerful message. So the brokers who have settled, now I think could be like, cool, we are now buyers in the marketplace. Brokers who haven't settled, right? And that's another way, by the way, speaking of that 2 billion line, think about that. 1.9 billion broker now can be like, we're a buyer now. The 2.1 billion broker.
That's another consequence of this.
It's another consequence. Of something like that. Now, again, it's not a big Compass, Ladder, not that size, but a $1.9 billion broker going and buying some 30-person brokerage, in a local marketplace, that's a big deal. That is a big deal. So let's not keep beating the dead horse. I think we've made it pretty clear what the big fuck up was. So anyway, hey, let's we're gonna wrap up here. I just want to make it real clear. I'm not saying that CMLS is doomed. I'm saying this is a minor mistake. I didn't want to beat up on them. Like I said, I was asked by a specific, by a reader and a friend, please write about this. So I did. And if I'm going to write about something, I'm going to be honest about it. Do I think this, no, of course not. The bigger news is the Department of Justice now freed up to go after NAR directly. So.
And I agree with you. I think that the paper was well written.
Yeah,
I mean, I like the arguments they're making, everything else. I mean, what the consequences of that are, we can all speculate. But I think it was well written. I think they did a good job with it.
It was a minor mistake. I think somebody just forgot to ask. Should we file this? I think somebody just forgot to do that. That's all. It's not the end of the world. Relax. So with that said, we'll see what next week brings. I feel like every goddamn week some major news happens.
Oh man.
So. Yeah. Hey, until then, thanks everybody for listening, for hanging out with us. And let me remind you, please help us pay our producers. Believe me, Greg and I are not making money from this podcast. We're doing this for fun, but we would like to maybe compensate the producers who do so much work for us. So if you can help us out, go to our YouTube channel, Industry Relations, and subscribe. Thanks very much, everyone. Peace.
Listen, content is everything. Two Brothers Creative makes it look easy. Right now, business owners really only have two options. The first option is hire a big firm. Now, this big firm's going to come in, make you think that they invented all the algorithms, and start charging you thousands of dollars every month. You don't want to do that. Second option is to do it yourself. Well, that means you got to learn SEO, SEM, copywriting, marketing techniques on the web. You should be really focusing on your own product. But now there's a third option. It's called Content in a Box. Give Two Brothers Creative 30 minutes a week and they'll handle everything. Plus, they'll show you how to bring it in-house later on. They'll rebuild your marketing foundation and give you tools and techniques and a new marketing playbook that'll actually produce real results and help you grow your business. Two Brothers Creative will give you the confidence and know-how to tell the SEOs and SEMs and all those other acronyms to get fucked. You're in control now. Get started today at thecontentbox.com.